So, Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it,
Well, maybe I haven't had my case yet.
And just like that, we're off to the races. Unconstitutionally vague is legal code for this law is so unclear, people can't reasonably understand what behavior is illegal. That's a serious constitutional challenge under due process. But here's the twist. Courts don't love striking down statutes unless they absolutely have to. So when defense says, maybe they haven't had my case yet, that's bold. That's courtroom confidence or courtroom gambling. Question for you. If a law is confusing but nobody's challenged it successfully yet, does that make it valid or just untested?
And, I'm happy for you to make new law, always.
Judge, I hand you DeContal versus State? I did. Just
DeCantel.
yes.
Yeah. Oh, look, it's out of Court 8 in Harris County. So why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. And we also watch the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he?
And just like that, we're off to the races. Unconstitutionally vague is legal code for this law is so unclear, people can't reasonably understand what behavior is illegal. That's a serious constitutional challenge under due process. But here's the twist. Courts don't love striking down statutes unless they absolutely have to. So when defense says, maybe they haven't had my case yet, that's bold. That's courtroom confidence or courtroom gambling. Question for you. If a law is confusing but nobody's challenged it successfully yet, does that make it valid or just untested?
Actively resisting getting into the car.
He tried exiting the vehicle, Judge. And that's why they had to push him back into it.
He leans forward. He's yelling at his mom. Record, call. The third time, they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there going, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal thing.
Yeah, I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Oof. That moment right there, that's escalation in real time. Resisting transport. It sounds official, but legally, officers can't just invent charges mid-argument. Probable cause has to exist before the arrest, not because someone questioned it. And the judge's reaction? You can feel the skepticism. When judges start saying, oh, come on, that's not great for the state. Let me ask you this. Should questioning an officer's authority automatically turn into a new charge?
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop.
I asked at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch it now.
We can watch the video, Judge.
Cue it up. Let's watch it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record it. Mama, look. Mama, look. Record him. Now you're under arrest. I'm under arrest. Yep, you got a new charge, Bubba. Resisting transport. Resisting? I wasn't resisting. You just resisted transport. Yep.
What the hell is that?
Now you got a new charge. Yep.
Come on.
Thank you, Judge.
Officers are working intake, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating legitimate.
I know, but no. All right, I'm
Do
with
you
you.
see why I'm so upset, Your Honor?
All right.
Okay. Thank you, Your Honor.
You can refile this as resisting.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
Mr. Narcisse, so you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine.
On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance of a weapon call at a hotel. The hotel staff stated that an unidentified third party alerted them that the defendant had a weapon. The defendant was detained, and a witness told the law enforcement officers that the defendant had a backpack behind a bush prior to the law enforcement officers' arrival. The backpack was recovered, and a handgun was found in the backpack. The defendant is currently 19 years old.
You like skip. How do they know the backpack was his? What was he doing wrong?
There was a witness, Your Honor, that stated that they saw the defendant hide the backpack behind a bush, and the hotel staff was able to identify the defendant as the individual they were told had a gun. And that's when the officer.
Was he just standing while black or something? What's he doing wrong?
They were just alerted.
No. I'm gonna find no probable cause in your case, Mr. Narcisse. Be careful, man. So many out there out to get you, put you down. You know, you're 19. Do something with your life. Don't become a statistic. Hang tight for me, man.
We're approaching on Mr. Jeremiah Cummings. That's the one about the deadly conduct.
I don't remember. I mean, I don't remember what I had for breakfast, so you're gonna have to refresh my memory. What happened?
Yes, sir. I'll just read the summary. On April 11th, 2025, in Harris County, Texas, an officer was dispatched to a family business. When the officer approached the defendant, he stated, "I'm not talking, I'll answer questions, gather these things, and grab a handgun and place it in the stand." The officer then drew a weapon and said, shoot me then. The deadly conduct, Your Honor, is alleged based on the fact that the defendant was holding the gun during the argument with the complaining witness.
Does that mean that if anyone ever gets into an argument and has a gun in their hand, that they're literally, I mean, theoretically guilty of a deadly conduct just by virtue of, and then what kind of argument can it be? What level of discourse must...
Okay. This is where science meets criminal law. Standard drug screens can sometimes produce false positives depending on the test used. But here's the catch. Courts rely heavily on lab confirmations, not just initial screens. The judge isn't wrong to demand documentation. Bond conditions are serious. A positive test while on bond can mean immediate jail. But if prescribed medication is involved, that changes everything. So here's the tension. Is this accountability or a misunderstanding of pharmacology?
there be for someone to be you know?
Right, and.
That can't be the law.
Talk about this one where it's not a terroristic threat or an act assault, and nothing was really said, it was like pointed, at her. We have also spoken.
So, I mean, think about this. Like, let's say you and I are arguing, right? And I'm mad at you and I just, I get the gun just to put it somewhere else,
Right. No, I get it. And I mean, wasn't charged as an act.
I get it, but
We have spoken to the complainant. I think I remember last time with this case, you wanted to hear from the complainant, just before you made a PC findings.
do you have anything else?
She's not, from what we can see, she's not on board. She wants to be around him. She said he had a gun,
Is he here?
No,
He's not
he
here.
waived his appearance.
Right. I remember. Yeah. All right. I'm going to find no problem.
All right. Did you want to also then speak to Mrs.
Come up, ma'am. You tested positive for meth. I can't let you go. That's just it's too much. I have to revoke your bond, ma'am.
I don't do nothing, I'm prescribed.
I just tested you. You tested positive for meth.
Yes, sir, but the medication that I'm taking, that's why I've been trying to get it.
Adderall doesn't test positive for meth. Show me a study. Show me something that says Adderall tests positive for meth. But no, I don't believe that's a good. I mean, I'm in pre-trial. It's just. Have you heard of Adderall testing positive for meth?
I have not heard.
No. You're supposed to give, when you're being supervised by pretrial, you are supposed to give them any and all prescriptions that you're taking so that they can cross-reference any positives with any kind of drugs that you're taking. Adderall doesn't test positive for meth.
That's not the only thing that I'm taking, sir.
So when she was in court the first time, she really was in a blank state.
I get it. I'm not talking.
And so at that time, when I asked about all the different prescriptions, she was very scatterbrained. She was able to provide me with the prescriptions that they gave her when she went to the hospital for the assault.
So let's do this. Let's do this. I will you can give that to them so they can check it out to see if there's something that will possibly test positive for meth. But I just don't think there is. I've ordered you not to use alcohol, illegal drugs. You're not to use. There may be things that happen in our lives. You're supposed to find a good way to be able to deal with, PTSD. We all have it. We all do. But you have to find a positive way to deal with things. And illegal drugs is not it, especially when you're on bond for a very serious crime. So take a seat from the jury box. I will have them check it out to see what, if anything would, but.
Just for clarity for the court, she's already provided prescriptions that she has when she went to test.
I don't know, maybe she has something different. And have you looked at all those prescriptions?
I mean, the whole list and disclosed of the prescription.
Okay, ma'am, take a seat for me in the jury box. I need you to understand that in life, right, we're not going to continue to hope and pray that something bad doesn't happen. We sometimes have to take proactive measures to ensure. You just had one dismissed. You've now picked up another one. If I were to plead you to time served, another proverbial slap on the wrist, and now we're going to let you go out there and hope that you don't kill someone or maim someone or you don't pick up another one, No, that's like the definition of insanity, wishing that something, over and over, just with a different result. No, this is proactive because here we can see what the issue is. We don't want you to come back with another DWI or much more kill someone because, look at the news. Every day someone dies from a DWI and it's just not fair when it's so freaking preventable by one damn button on your phone. How much money have you spent on both DWIs so far where one button and a $40 fee would have gotten you from A to B? You know what I mean?
Sir.
That's now what we have to do to intervene in hopes that you learn from this so it doesn't happen again. So you've worked out an agreement where they're offering you 1 year in jail and this to be probated for 15 months. As part of this, you will do
This right here, this is the part people underestimate. A guilty plea isn't just pay the fine and move on. Its collateral consequences, license suspensions, insurance spikes, employment barriers, immigration risks, future enhancements. That 0.15 reading, that's an enhancement level, meaning harsher penalties next time. And the judge is basically saying, this is your warning shot, because statistically, repeat DWIs escalate. So here's the question, is probation a second chance, or the last one before real jail time?
Repeat offender DWI education class, a victim impact panel, a TRAS, which is an evaluation to see what are the conditions you may need, if you need other conditions. If they assess them, you must fulfill them. No drugs, no alcohol, no breath test refusal, meaning that if you're pulled over, an officer asks you to submit a breath test, you must do it while you're on this probation. Guardian interlock, 25 hours of community service, and a $100 one-time donation to Mothers Against Drug Driving. You have children.
No, but I have a 13-year-old brother that relies on me.
Okay. If he does a parenting class, then I'll consider the community service way.
Sure.
The idea, all we want is that you learn so that you, in 20 years, this has made enough of an impact on you that you think twice. Oh man, shit, that was such a bad experience. I don't want to do that again. It's either jail or it's a crap load of fines and fees. Do you understand?
Yes, sir.
If you ever have a problem while you're on this probation, all you have to do is come back, let us know. We can work through anything. There's nothing too big, nothing too small. But the worst possible thing you can do is drive without a license or insurance, start using, or pick up another DWI. So you understand?
Yes, sir.
The other thing that if you just take off, abscond, that's also an instantaneous warrant. If you violate this probation, that's what we do. We issue a warrant. We have a hearing to determine whether you violated it. If you do, you're looking at an entire year. Do you understand?
Yes, sir.
You give up the right, you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, this is going on your record now. It'll be there for the rest of your life. Do you understand?
Yes, sir.
From now on, you're facing a minimum of 90 days in jail. You ever pick up another one. Do you understand?
Yes, sir.
And I'm going to tell you now, you get pulled over, an officer, the first thing they do is they look at your record. They're going to see DWI, DWI. What do you think they're going to do? Do you think they're going to harass and harangue the hell out of you? Every time you get pulled over. And if they smell anything funky, it's probably not going to go well. You understand?
Yes, sir.
Is it true or untrue that you had a 0.15 or above in this case?
It's true.
True to the enhancement. All right. How do you plead to the office? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow this agreement. I'm going to send you to it. I'm not going to suspend your license now, but I'm going to tell you, can you look up his license please to see if it's suspended?
Judge, I'm sorry, I missed his name.
Arredondo.
It is not eligible, Your Honor.
Okay. So you will be signing a non-driving affidavit. If you drove here today, you are not allowed to drive home. Your license is suspended as of this time. If we catch you driving without a license, I'm going to lose it. Do you understand?
Yes, sir.
Do not drive. You are required to have a guardian interlock, and every officer, because we send notice to DPS, every officer in the state knows if they pull you over and you don't have an interlock, you're going to jail. Do you understand?
Yes, sir.
That's for the traffic, right? That's why it's ineligible, right? So
I
traffic.
believe so. I took care of those yesterday. So.
Judge, I believe his license may be showing ineligible due to a traffic ticket. If we can get that sorted, can we come back and?
I'm okay with an occupational as long as he's in compliance, okay? The other thing is this, is he is now taking a subsequent DWI education class. DPS is probably going to suspend your license regardless because of a subsequent DWI education class, if you've already taken it. Did he do a diversion and it got dismissed? As part of the diversion, you have to do a DWI education class. Subsequent ones get your license suspended. So I would check with DPS first. Don't just start driving, when you take care of that ticket, because they're going to probably suspend your license again. And this time it may be like a 2-year suspension. I'm okay with an interlock, with a An occupational, as long as he's in compliance.
Yes, Your Honor.
And he has an interlock first. Okay. All right, so we're going to have you meet with Shatori for all your conditions, and then good luck to you, sir.
Thanks, sir.
Thank you. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine.
On March 1st, 2025, the officer observed a white Honda CRV involved in a minor accident. The defendant was traveling southbound on Dennis Street when he struck a 2016 gray Lexus. The defendant admitted to consuming alcohol recently, and standard field sobriety tests were administered. HGN 4 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant refused breath.
Right? He admitted to consuming alcohol recently, so what?
And Your Honor, there are no other indications of intoxication listed in the DIPS.
No slurred speech, no bloodshot eyes, no,
We don't have that.
not even an odor of alcohol.
No, Your Honor. None
Your
of that.
Honor, what we do have is that there's an accident and another officer told him that he thought that the defendant was intoxicated. We don't know what the other officer observed.
Right.
Based on the DIMS
Yeah.
facts.
All right, I'm gonna find no probable cause. Mr. Medrano, hey, be careful, man. I mean, look, every single day, someone dies from an alcohol-related collision in our county. Every single day. $50, $40, Uber, anywhere you want to go. Don't matter where you want to go. You know what I mean? You're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
On March 1st, 2025, the officer was dispatched to a major crash on Ella Lee Lane in Harris County, Texas. The witness stated he heard a loud crash coming from outside his residence and observed the defendant's vehicle crashed into a blue Subaru. The witness observed the defendant sitting in the driver's seat of a red Toyota Corolla and removed the keys and smelled an odor of an alcoholic beverage and bloodshot eyes. The officer observed an odor of an alcoholic beverage, bloodshot eyes, and slurred speech. The defendant stated he had consumed 4 margaritas and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 4 out of 4. The defendant did not consent to breath and a blood warrant was signed and executed.
Mr. Menchu, I'm going to find that there's sufficient probable cause to go forward with your case. Any prior DWIs and a license?
No prior, Your Honor, and there's no license on file.
Mr. Menchu, I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it on a daily basis, they will put a detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you will be shipped off to immigration. Heed this warning. You will not get another. I see it happen every day where people get ICE hit detainers and they sit in custody for 6 to 9 months. I'm now putting conditions on your bond. If you violate these conditions, then I will put you in jail. The first condition is you are not to drive. If you do not have a Texas driver license and liability insurance, then you're not allowed to drive. I don't care what is going on in your life. I don't care if there's a burning building and you have to save 50 people, babies, whatever. Do not drive. The next condition is you're not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol and or illegal drugs, likewise, your bond will be revoked and will go into custody. Pre-trial services is going to call you to go take a test. If you fail to show up for the test, then a warrant will issue for your arrest. Do you understand what's expected of you?
Yes.
You get no more warnings. If you don't believe me, ask Marcos. He'll tell you good and well. For now, I will have you come up to us here, swear to us that you're not going to drive. I will get you to Ramona where you will sign a reset. Good morning, Ms. Ford.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
I apologize, what's the last name, Your Honor?
P-O-U-R.
Okay. On March 2nd, 2025, the officer was dispatched to an accident on the 4500 block of Southwest Freeway, and the defendant was passed out in the passenger seat of a tow truck. The officer noticed that her eyes were low, her speech was slurred, and her breath smelled like alcohol. She had also urinated on herself. The defendant stated she had one drink and was coming from a club, and the defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
Where was she driving? What was she doing? All I know is that she's sitting in a passenger seat of a tow truck. How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? I mean,
yes, Judge. And the statement made statements stating that she confirmed that this was her vehicle and she drove it to the crime scene. The defendant confirmed that she was with only her and no one else was with her. The defendant confirmed that she was on her way home from a club where she consumed alcohol, and the defendant's vehicle was found stalled on the shoulder of a busy freeway. And the officer wrote that led the affiant to believe that that there was no one else that fled from the scene. And the officer wrote from the affiant's training experience that he believed that the defendant was the driver of the vehicle based on the statements made to him and finding the vehicle.
did anyone see her drive? Did the tow truck driver see her drive? How long did she drive? When did she drive?
We don't have that information.
So it says that there was, Deputy DuPont was dispatched to a one-car minor accident and the vehicle was leaning on its side and stuck in a muddy ditch. The defendant was passed out in the driver's seat with the key inside the ignition and the engine running. That deputy woke up the defendant.
So someone sees her in the ditch.
Wait,
I think you might have a different.
oh, sorry, that was the wrong case, Judge.
In this
Sorry,
case,
sorry.
she was passed out in the passenger seat of the tow truck, and there's no other information in regard to her driving besides the statement she made. So there's no one that observed it, Your Honor. And we understand.
Let's do this. I'm gonna appoint you a lawyer today so we can have someone take a look at the case for you, okay? Ramona, do you mind appointing someone for Ms. Moore, please?
Okay, Judge.
Just do me a favor, just take a seat for me in the jury box, will you, please?
Boom. That's a fundamental rule of criminal law, the corpus delicti doctrine. A confession alone, without corroborating evidence, is generally not enough to establish a crime occurred. You need independent proof. And the judge is digging in here, which is fascinating. Because this isn't about whether she was intoxicated, it's about whether the state can prove she was operating the vehicle. No eyewitness, no officer observation, just her statement. So now we've got a real legal chess match brewing for Monday. And I love when judges say, "Bring me the case law." That's when it gets interesting.
Okay, so it's a DWI, Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
We have her in the passenger seat of a tow truck.
Right. So her statement alone isn't sufficient. That's all they have about her driving.
And Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the the encounter with the defendant took place 2 hours after when she left the bar.
But none of that same, well, go ahead. Calm down, T. Until you get-
So do we have an officer that actually sees her in the car in the ditch?
No, Your Honor, the car is just found in the ditch with the tire blown out, and the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Why?
Their statement alone can't be sufficient evidence. They need corroboration.
And the corroboration we have is that when the officers arrived, there was nobody else on the scene. There was a crowded freeway. There was nobody who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not going to corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is insufficient?
That's a rule. I can give you a case if you want.
Yeah. Yeah. I do.
Okay, well, give me time.
Yeah. And I'm willing to, if you want, maybe like we can revisit on Monday.
Okay.
Because I want to give you time. I want to
waive her appearance for Monday.
Yeah. I'm going to put her under conditions though, but yeah.
Understood.
Okay. But I'd like to do a deeper dive on the PC and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the officer.
Let's reach out Monday and we'll do more, I guess, a formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond. In this. If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. Could you guys run her license, please? And any other prior DWIs?
What about Your Honor? No prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand?
Okay. Your Honor.
Great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign a reset, I'll have you meet with Felicia if your bond conditions. And after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions.
Yeah, she needs to sign the reset, but yeah. Mr. Crump, you are charged with unlawful restraint. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 2:27 p.m., the officer was dispatched to a disturbance call in Harris County, Texas. Upon arrival, the officer met with the complainant, who stated that her child's father caused the disturbance and got her kicked out of the motel. The complainant stated her and the defendant got into an altercation due to the defendant trying to take a child away that they have together, and the complainant not wanting to be together anymore. The complainant was attempting to leave the room when the defendant began sitting against the door, preventing her from leaving. The complainant stated she grabbed the defendant by his hair and started striking him with a closed fist because she was in fear for her safety due to a previous offense report from Harris County Sheriff's Office. The defendant called his brother, and the defendant's brother entered the room and started recording the incident, and the defendant was trying to leave with the child, and the complainant attempted to get him away from the defendant. The complainant was unsuccessful, and the child bumped his head on the door, and the complainant stated she knew the defendant by name, age, and sight. The officer was able to locate the defendant's driver's license and positively identified the defendant. Another call for service came from another location regarding an assault that occurred at the original location. Upon arrival, the officers met with the defendant, who stated he was assaulted by the complainant. The defendant stated they were having a conversation in the restroom of a hotel and that he was standing in the doorway when all of a sudden the complainant became belligerent and started cursing him, telling him to leave. The defendant stated he was punched in the face and suffered a busted lip, and the defendant stated his brother was called to mediate and be a witness. Then the complainant began cursing at the brother. The defendant stated the complainant grabbed the child by one arm and threw him on the bed like a rag doll.
Mr. Crump, I'm going to find that there's probable cause to go forward with the case. Did she ended up getting charged as well?
I do not see a charge for the complainant, Your Honor.
So just don't have any contact with this person. That's all I'm asking you to do. You know, sometimes when you have cancer in life, what do? You cut it out, because if you don't, it kills you. Some people in life can become a cancer to you as well. So that's it. I don't want you to have contact with this person. Do you understand? If I find that you do, I'm going to revoke your bond. I will put you in jail. I'm also ordering you not to be in possession of weapons as well, Mr. Crump. You have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay, I'll have you fill out an application. I'll take a look at it. I'm gonna have you sign a receipt with Ramona. After that, I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, come on. So can you file no contact and no weapons?
Yes, Judge.
Tyler.
A couple quick things I forgot.
Okay.
On the two clients I approached on earlier, I didn't ask you to sign the blood discovery orders.
I'll put them in. I'll sign everything for you.
Okay, I don't need one to show from you.
Is it the standard one, or is it?
Standard.
Okay.
Okay.
So some of the stuff that they've seen already.
We filed it. It's in your queue.
This is just a standard blood discovery.
Standard blood discovery.
Then I'll
order.
sign it.
You will sign them today?
Yeah, of course.
Okay, thank you.
Absolutely. Guys, can you put it in the queue?
Yes, sir.
For both clients?
Yes, sir.
I'm sorry, Judge, one of those was mine, one was David Smith, so if you see my name.
I got it.
If you can sign the other one as well, I appreciate it.
Yeah.
Judge, on Jamal Crump, you ordered him to have no contact with the complainant. They share a son together. Is there any way they could have a third party for visitation?
Well, of course. They can always use someone else, but I don't. Come up, Mr. Crump. I know that you're upset that they filed this case. But when I mean no contact, I absolutely mean it. They're going to call this person now to let them know of the bond conditions that have been filed. So if I get wind that you have contact with this person, then we're going to have issues. I get that you have a son and you should have, or a daughter, I don't know what it was, but you should have access, because every father should have access to their child. And I want you to have access to your child, but you got to do it the right way. You know, use someone who, like James is saying, a third party. Don't take it upon yourself to try to do stuff, because it's going to go sideways real quick. Maybe if you have parental figures like your mom, your dad, someone that she probably likes, right? If she doesn't like your brother, that's probably not a good person to use to try to get contact with the child. So try to find someone, maybe he can also help you too. Maybe he can help facilitate as well, where she drops off the child at a McDonald's somewhere, and then you come and you get the child for a certain amount of time, and you drop the child back off at a McDonald's. But don't do stuff your own way. Are we good? Okay.
Thank you, Judge.
Yeah. Your iFront, is it Shake?
Yes, sir.
Sir, you're charged with 3 cases. You're charged with terroristic threat of a family or a household member. You were charged with assault of a family member. You were charged with interference with emergency request for assistance. All 3 of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Can I say something or no?
About the case, or do you have a lawyer?
Obviously, attorney, yes.
I'm sorry?
About attorney, and I need to discuss something, sir.
You are an attorney?
No. I need attorney. I need hair.
We'll talk later. Let's do probable cause first. You have the right to remain silent.
Yeah.
Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 23rd, 2025, in Harris County, Texas, the officers were dispatched to a threat to life call. Upon arrival, the officer met with the complainant, who stated that the defendant is her husband. The complainant stated that the defendant and her got into an argument, and that the defendant stated, "I'm not afraid of the police. I will grab that knife and cut your throat." The complainant then stated that the defendant had, on November 16th, 2024, assaulted her. The complainant stated that the defendant grabbed her by the top of her dress, causing scratch marks, and punched her in the chest, causing bruising. The complainant stated that she attempted to call 911, but the defendant ended the call.
here for example.
Sorry, patience.
The terroristic threat was I'm going to grab a knife and cut your throat on it. Okay. Mr. Sheikh, I'm going to find that there's sufficient probable cause to go forward with your case. Do you have the ability to hire a lawyer?
So this also is the attorney.
I'm not going to listen. You have the right to remain silent. Exercise that right. Anything that you say, they're going to try to use it against you to prove guilt. So what I can have you do is I can have you fill out an application. I will take a look at it to see whether you qualify. We don't give appointed lawyers like it's candy on Halloween. You have to qualify, and if you do, then I'll take a look. But I need you to fill out everything. As it stands now, I am ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. You are not to go within 200 feet of where this person lives or where this person works. Do you understand?
Jamal Crump?
Do you see whether a order for protection has been entered in this case? Guys, let me see.
And Judge, the DVD prosecutor is on the phone.
Oh.
There he is.
That's
Yes, Judge, I was able to make contact with her. I'm not sure what the discussions were beforehand, but we're going to be asking for no contact to keep whatever the residency restriction is in place right now.
She does not want to have contact with her. Okay.
And I don't see a protective order in place.
On the AFM,
Is there one in the AFM?
Yeah.
But I'm going to also do one on the terroristic threat.
Yes, Judge.
I want you to understand something and take me seriously when I say this, that when I mean no contact, I absolutely mean no contact. I don't care what's going on in your life. I don't care that you need clothes. I don't care that there's a child involved. I don't care that you need to go get the car, whatever it may be. No means no. And if you violate these court orders, the state can and probably will file a violation of a protective order against you. That is the capital murder of misdemeanors. Do you understand? I am now entering in what's called a magistrate's order for emergency protection on the terroristic threat. This is a court order that identifies the complaining witness as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? This is what I'm saying, that if you violate this order, they can file additional charges against you. Now, Deputy Miranda will give you an application. I'll have you fill it out. I will take a look whether you qualify. Anything else you want? Oh,
No, Judge, we're comfortable with no contact.
so can you also file the no contact and no weapons so that it outlives the, okay. Do not leave until you sign our additional bond conditions.
Yes.
Okay, please.